I am a lawyer, but I am not necessarily your lawyer. The materials discussed in this podcast are for informational purposes only and should not be deemed legal advice. If you have a specific legal question according to your circumstances, then I encourage you to speak with an attorney licensed in your jurisdiction. Welcome back to another edition of Ag Law Today, and we have a special guest coming from New York City. I actually went to law school with this particular guest. I have Dan Timins on the line. Dan, why don't you tell us a little bit about yourself?
Hi, Carrie. Dan Timins. I'm a trust and estates and elder law attorney, as well as being a certified financial planner, and I own a firm on Madison Avenue here in Manhattan, New York City.
So today we're going to focus our conversation on trust. And Dan, could we just start the very basics here? What is a trust?
Perfect. A trust is a written legal document that effectively is meant to help control your finances either while you're alive, once you've passed away, or both. A trust is something that you create typically on your own with the help of an attorney. And then you need to fund the trusts with certain types of property. And these are all concepts we'll be reviewing.
All right. So what are some major differences between a will and a trust?
Terrific. A will and a trust, the big difference is they're different types of contracts. And there are several differences, but the similarity between the two is this: you can state the terms upon which people receive property in both of them. But a will is a public document. People don't realize that when you pass away, your will is brought to the local court to be probated, which is a legal process that takes several weeks or months depending on what state you're in. Whereas a trust is a private document. It does not need to be filed with any court except in the case of perhaps a lawsuit. So it's private, it's expedient, and it's far more efficient at transferring your property when you do pass away.
So you mentioned a few of the advantages, but are there other key advantages in using a trust?
Absolutely. So for example, if I wish to leave money to a minor child of mine, I can't leave it to them outright. So if I say in my will I leave everything to my daughter, and my daughter is 14 years old when I pass away, that's going to be a problem. A trust, on the other hand, can say such things as, in this situation, I want her health care and education and maintenance and support paid for until she's 23 years old. She'll get 20% of what's remaining in trust when she's 25, another 20% when she's 30, et cetera, et cetera. It protects funds potentially from divorce that you're leaving to other people, and it protects the beneficiary from their creditors in substance abuse as well.
What are some disadvantages?
The big disadvantages of trusts are that, number one, surprise, surprise, you have to pay an attorney, and people don't typically like that, but setting up your own trust is not very easy to do. I typically almost universally recommend against it. The second part is the fact that there are expenses both in time and in money. It's going to take time for you to retitle different types of assets, to change deeds and other things that quote unquote fund your trust. So there's a time investment and there is a financial investment.
When do you recommend that people have a trust?
There are a few times, and trusts are pretty flexible instruments. Certainly when you think that you're going to have a contested estate because perhaps you're leaving additional funds to one person instead of another. Sometimes you want to be able to qualify for things like Medicaid. Well, some states will allow you to have certain assets provided they are in certain types of trusts. A big part of the situation, though, is really when the beneficiary is their own worst enemy. When a child or a nephew or niece, whatever, has creditor problems, or when they have substance abuse issues, you tend to not want them to have money in their pocket. You're able to name someone who can oversee the process instead and protect the beneficiary from themselves.
So a few years ago, I guess it's been a while now, Susie Orman was on the air. I don't know if you remember Susie, but whenever when going through people's financial health, she would automatically give them an F if they did not have a living trust. So she thought in her mind, every single person, no matter their income level, no matter their circumstances, should have a trust. I'm just curious on your thoughts on that.
In a perfect world, everyone runs 4 miles a day and eats perfectly healthy and gets 7.5 hours of sleep. So, at some level, though, she is correct in that in a perfect world, everybody does have a trust and all of their property is being transferred by that trust. The truth is certain people can get away without having trusts. They tend to be smaller knit family groups, like perhaps a couple who's married or maybe a parent with only one child. In those situations, you don't necessarily need a trust. But again, it's preferable for any of the reasons we've mentioned so far, as well as so many others.
All right. So in the broadest terms, what is the difference between a revocable and an irrevocable trust?
The proof is in the word. When you create a trust document, if you want to be able to cancel it, it must be a quote-unquote revocable trust. And a revocable trust is more or less like your alter ego, where you create money and you manage it for your own benefit. An irrevocable trust, on the other hand, is one that, surprise, surprise, you cannot change. And so you would say, well, why would I even want to bother with one of those if I can have a trust that I can change? If you have an irrevocable trust, you're able to take advantage of certain things such as creditor protection, qualify for government benefits, and last but not least, take advantage of some estate tax savings, but only if it's irrevocable.
Yeah, a year ago, I had a farm family in my office, and they were concerned because the grandfather in that situation was in a nursing home, and they're concerned about losing their farm, to help pay for this nursing home. But at that point in time, it was I'm not going to say it was too late to look at irrevocable trust, but do you want to speak a little bit about the look back period on that when it comes to elder care?
Yeah, no problem. Medicaid in and of itself is a program that's run by the federal government, state governments, as well as at the county level. And the laws differ state to state, but generally speaking, anyone who goes to a nursing home within a 5-year period of giving a gift to someone could have that money pulled back by the government. So if I left $100,000 to my daughter, and then I needed to go into a nursing home 3 years later, the government's going to say, hey, before we pay for Medicaid, we need that $100,000 back. So that can really hit people. Time is definitely against you when you're doing Medicaid and elder law and disability planning. So don't waste your time. Get on it now.
What are some specific types of revocable trusts?
Terrific. Well, there are several. They tend to all be not just in the term revocable, but let's say, for example, what they're meant to accomplish. So one type of revocable trust is the one that you create specifically for yourself, where you are the creator of the trust, meaning that you draft the trust with an attorney's help and you fund the trust with property. You are the trustee of the property and the trust. And then you're the beneficiary as well, meaning that you just sit back and enjoy the rewards. And this is like your life. This is your alter ego. The benefit there is that there's no additional income tax paperwork that needs to be filled in. The downside is you don't get any of those benefits that you get with irrevocable trusts. You can also have a joint trust with another individual or a trust that names many individuals. But the idea is that when you have a revocable trust, you can change it, or the parties who are also members of that trust can change it.
So let's talk a little bit about who's who in a trust. Let's start with what is the difference between a trustee and an executor of a will?
Great question. So your executor and your trustee are both fiduciaries, meaning that they handle the financial affairs. The big difference between the executor to your will and a trustee is this. The trustee just cares about the money in the trust. So if you pass away and you leave a life insurance policy directly to one family member and everything else under your trustee has no concern and no control over the money in the life insurance policy. They just care about the money that's in the trust. An executor, on the other hand, collects your property, pays off your creditors. They can bring a wrongful death lawsuit. They can clean out your closet. They distribute your money to other individuals. Your executor under your will, quote unquote, steps into your shoes. So they're not just a financial individual. They can ask for your medical records and everything else that you were able to do while you were alive. In the meantime, a trustee's job is ongoing. An executor's job is a one-time deal. Now, an executor may be done with their job 3 or 4 years later, but you could conceivably have a trustee working 20, 25 years, investing money for the beneficiary, paying out expenses for the beneficiary, filing income tax returns for the trust, and ultimately distributing all remaining funds to the beneficiary.
So who exactly is the beneficiary in a trust?
That's going to depend based on the trust. So if I create a revocable living trust, so I can avoid probate and make sure if I'm incapacitated, if I have a stroke or get severe Alzheimer's, that I have a backup who's going to be able to handle my affairs, I would be the beneficiary during my life. Several people, however, create trusts that name other people as beneficiaries, such as their children, or maybe they name their parents as beneficiaries. Sometimes I'll be the beneficiary of a trust I'm trying to qualify for Medicaid, but need limitations on that money. The beneficiary is the person who more or less is permitted to receive either the money or the benefits that are generated from the trust, paid for or out by the trustee.
So since moving home about 1.5 years ago, I've been doing a few estate probates here. So getting a little bit into that. Can you speak briefly on the difference between probating a will as compared to trust administration?
Oh, I could speak for quite some time about that, but I'll try briefly. When you probate a will, it's not that different than what took place hundreds of years ago in England. People forget our Anglo-American jurisprudence. The whole system was created in England hundreds of years ago. When I probate a will, I need to get the witnesses to swear that it was my signature. They have to sign, typically in front of a notary. In some states, I have to sign in front of a notary as well. I have to declare it to be my will. The court has to sanction the will, saying that we agree with this. And they're also going to have other family members placed on notice. The onus is on your executor to validate your will. A trust is the exact opposite. If people have a problem with a trust, it's their job to try to fight it. A trust tends to be pro forma, just assumed to be valid on its face, and anyone who's trying to contest it, the burden is on them to contest it.
So I don't know what you think about this hypothetical, but when people come to my office and talk about trust, I usually describe trust as like a bank account. So you could open up a bank account, but it doesn't mean that there's any money in the account. So you have to put money into the account, which is called trust funding. So I'm curious on your thoughts on what exactly does it mean to fund a trust, and specifically as it applies to agriculture, because we're talking about farmland, we're talking about livestock, we're talking about farm equipment, and cash assets as well. So how does one fund a trust?
So funding a trust can be done in two ways. One of which is with future assets, things like life insurance. When you pass away, you would name the trust as the beneficiary. So the beneficiary of my life insurance policy isn't going to be my wife. It's going to be the Daniel Timins Revocable Lifetime Trust. Or the beneficiary of my retirement plan, which pays to someone else in the future, may be my trust. But for current assets, that's where the real proof in the pudding is that is where you really need to fund your trust. Things like agriculture or land involved with agriculture, you need to change the deed to actually be owned by the Carrie Rinker Revocable Lifetime Trust. Or you need to change the LLC and assign the LLC interest to your trust. That way it will avoid probate and not pass by your will. If you have investment accounts or bank accounts, they have to be named after the trust too and have the trust tax ID number, which if it's a revocable trust, usually tends to be your social security number. But an unfunded trust does absolutely nothing to effectuate your estate planning.
How far do you take that, Dan? I mean, should people be changing the titles to their vehicles?
That's a great question. You know, Again, in a perfect world, everyone has every piece of property that they own transferred by their trust. Now, that being said, I know some people who'd rather die than go to DMV for 3 hours and have them try to figure out how changing the title to a car to your trust should be done. That being said, I will tell people who have expensive cars that they absolutely should go to the DMV and change the title to the trust. People who have expensive pieces of equipment, large bobcats or big hose, something like that. Same thing, I will say, change the title of the equipment to the trust just because it avoids the weight that's associated with probating that estate asset if it passes by your will.
Yeah, and with cattle that are registered, I've even gone so far to ask clients to change the registration paper to be the trust. So I know there's some conflicting opinion about that, but
I think a great idea. Great idea.
So what if a trust is not the owner of current property or the beneficiary of future property? You haven't funded it properly.
So that's what we call kindling for fireplace. A trust that has no property that it owns now and is never going to be the beneficiary of any future payments, such as life insurance or retirement plans, is an unfunded trust. And an unfunded trust is like an unfunded bank account. You can't do anything with it. So the whole idea of having it means nothing if there's no funds that are going to be in it now or in the future. It's ineffective. I just say, scan the document and then light it on fire some night just for kicks.
So speaking of bank accounts, and you were also just talking about leaving your life insurance and retirement plans to a trust. Can you talk a little bit more exactly on how people can do that?
Very good. So for things like life insurance, your life insurance policy has a beneficiary designation form. Don't forget, a life insurance policy is a contract with the life insurance company, and they're saying when the insured individual passes away, because someone has paid for these premiums, we promise to pay out a beneficiary. You, as the owner of the policy, get to name the beneficiary, but you actually have to change the beneficiary, in this case, to your trust. Now, why would I do that? Well, perhaps I trust my son to handle some of his finances, but not all of them. Or perhaps I have a daughter who has significant creditor issues. If I leave her the life insurance policy, the creditors might be able to get right at it. If I leave him the life insurance policy, he may spend the money on some substances. By leaving the funds in a trust, I can name a trusted third party who will still use the money for their benefit, but at the same time, make sure to protect the funds from anybody who may try to abscond with it or take it for their own purposes.
Let's shift gears a little bit and talk about testamentary trusts. First of all, what is a testamentary trust and how does it differ from other kinds of trusts?
It's funny. I had worked at a law firm for several months before I was an attorney and never even had the concept of what a testamentary trust is. And it's so simple. As opposed to a living trust or a revocable trust, which is created during your life and is a separate document, a testamentary trust is a trust that's created in your last will and testament. So your will has several aspects to it, but if you have children, for example, or minor beneficiaries or disabled individuals, your will can actually create a trust that can be used for their benefit, again, as opposed to just saying, I leave everything to my children equally. The testamentary trust is only in effect once you pass away and your will is being probated. So people who have a testamentary trust shouldn't say, I have a trust. They should say, I have a trust in my will that'll be valid someday when I finally pass away and that will is probated. And that's just too long of a statement to make.
Do you recommend testamentary trust? Is it a better approach?
Again, in a perfect world, you probably want the living trust because a living trust, if every piece of property transfers by that trust, avoids probate. Now, I'm not saying that probate is necessarily a bad thing. Probate has been used for hundreds of years to transfer my property to someone else when I pass away. And a trust in the will also have the benefit of protecting the funds, again, from creditors or from the beneficiary's own lifestyle, or to help them to qualify for government benefits. But again, the big issue is this. The funds do have to be probated. It's public just like any probate, and a testamentary trust does not save any money on estate taxes, on income taxes, on creditor issues, or for certain types of government programs.
So what type of controls does a person have over the trust when they die?
When a person passes away, a trust effectively, even if it was a revocable trust during your life, becomes irrevocable. But you've already taken time out to work with an attorney and with your family members to figure out what you want in that document. So I can say, if I don't approve of this beneficiary's choice of spouse, I don't want this beneficiary to receive all the money if they're still married to them. When they do get divorced, or if their spouse passes away or they pass away, whatever the case may be, I would rather have my grandchildren receive that money. Or I don't approve of their lifestyle choices. I want them to change their lifestyle choices, or I will leave this money to the other siblings. So you can pull the strings like a puppeteer from the grave, and that's a term we use. You pull the strings after you pass away. It just has to be codified in the trust before you pass away.
So how can trust really help with estate taxes?
So trusts help in any one of a number of ways with estate taxes, and there are several types of estate tax savings trusts. One, the most simple, just says this: each of us has a pool of money worth currently over $11 million for each of us that avoids estate taxes. Now, let's say I happen to be one of these people who has $20 million to my name. I, just have a very good month in the office. Well, if I pass away, I leave everything to my wife. She doesn't receive any estate tax. There's no problem. I can leave unlimited money to a spouse without estate tax. But when she passes away, because she's passing away with more than $11 million, she will have estate taxes on $9 million of that. If I had created a credit shelter trust, I am able to use my lifetime estate tax exemption, currently $11.18 million. She can have access to the income from that. And then when she passes away, my portion passes estate tax free and hers passes estate tax free up to that $11.18 million.
So a few weeks ago, Dan, I was speaking at a cattle conference, and I got this question from the audience, and I'm curious on your response. Basically, the question was, can trust help in all cases for people to avoid estate taxes?
Great question. And everyone thinks that, because everyone thinks that a trust is a magic bullet under every circumstance. And the truth is no. The majority of trusts do not save money on estate taxes. Now, I mean that in the sense that the number of trusts that are written tend to not be written for solely the sake of saving money on estate taxes, and sometimes they tend not to at all. Trusts tend to be written more so to avoid probate. They tend to be written to qualify for government programs or avoid creditors. There are some, and several, that do avoid estate taxes, but the vast majority of them do not. Just because it's a trust does not mean it avoids or minimizes estate taxes.
What kind of irrevocable trust will give a person creditor protection?
So this has been a big thing since the beginning of time, since we started having formal creditor rights. How do we protect our money from someone who wants to take it? So, if I'm driving my car and I hit somebody with the car, I know they're going to come after me and sue me. Well, I don't want them to take my money away, so I'm going to try to create a trust that protects that money. Well, that circumstance may not work so well. But, there are certain states out there, and I'll name them. It's Nevada, it's Delaware, some of these trusts that are in Alaska, any state that seems to be kind of remote and far away and not a lot of people. These trusts can protect your assets if you give the trust a little bit of time to hold it before a lawsuit. If you get into a lawsuit or you create an action which will lead to a lawsuit, I hit someone with a car and the funds are not already being protected by a trust, I'm kind of too late. So the sooner you create these documents, the better. And again, you need to fund them.
What is the income tax treatment from both the revocable and the irrevocable trusts?
Well, when you're dealing with a revocable trust, remember, you are the person who creates the trust, you administer to the money, and you're the beneficiary. So it's kind of like your alter ego. So any money that is generated by a revocable trust tends to be taxed at your tax level and under your Social Security number. It doesn't need to be its own entity, which is a great thing. Some irrevocable trusts are like that as well. They are called grantor trusts. But more importantly is this: irrevocable trusts that do not transfer money to the beneficiary but continue to hold on to it, such as something held for a minor or someone who's not ready to receive the money, those trusts pay higher income tax rates than you and I do. So whereas a married couple will pay the top 37% federal rate at $600,000 of adjusted gross income, a trust pays 37% starting around $12,000. So just a small amount of income can really hurt from an income tax perspective when you're dealing with irrevocable trusts and not distributing the funds.
A few months ago, I was speaking on farm leases, and one of the people there asked me how you dissolve a trust. Like, is it that complicated? What are the steps that are involved with it?
There's two different aspects to that. One of which is you just want the IRS to know this trust is done. And in that case, you file an IRS Form 1041 typically, and that tells the IRS, we are closing down this trust. Here's the last trust year, et cetera. It's done. So that means the IRS, the statute of limitations start to roll. They have 3 years to contest that unless there's been fraud involved. More importantly is if I have a trust, I'm trying to let family members know, hey, this is no longer in effect, or a financial institution, I do need to sign a document that says I'm hereby canceling or revoking, what have you, this trust. It only works again for revocable trusts because by their nature, you cannot change or dissolve irrevocable trusts absent having all the money distributed and it being, again, worth nothing.
To close, you're sitting there from New York City, and we've got listeners from all over the country. What advice do you have for people who are looking for a trust and estates lawyer wherever they are?
The most important thing is that the person not only holds themselves out to be a specialist or a focused individual in the trust and estates arena, but more importantly, in the arena that you yourself are interested in. Some attorneys are going to be great as trust and estates attorneys who are dealing with creditor issues. Others will do exceedingly well saving money on estate taxes. But your job is to remember that this is a very rich field. It's not easy stuff. There's a reason attorneys charge so much money. It's because they're in demand. Typically, the best ones are in the greatest demand. So I would say make sure to do your due diligence and make sure that the individual you're meeting with is not only competent, but they are a specialist in that area.
And so along those same lines, what kind of questions do you think that people should ask during the interview process?
What I would wish more people would ask, and what I would recommend that people ask, tends to be this. I would ask the attorney, so what areas of practice are you involved with? What kind of law do you practice? I wouldn't say, do you just do trust and estates? Let them trip themselves up and say, well, I also do real estate law and criminal law here and there and admiralty law. So ask them what kind of fields of law they practice. You can ask how long they have been in practice. That's not a problem. And I would ask straight up front also, what are your fees? You know, if you've been interviewing a few attorneys and the one that you're in front of seems to be charging way too much or way too little compared to the other ones, something's probably not right. The problem with these types of legal services is that you do them so infrequently, you don't know when you're getting a good deal or bad. Go by the law of averages and make sure that the person you're meeting with has fees that are in line with what you're hearing elsewhere.
That's great advice. Thanks, Dan. And how can people contact you?
I can be reached on the internet of all places. My website is timinslaw.com, and that is www.timinslaw.com. And feel free to pop me an email from there if you so desire.
All right. Thanks, Dan.
Thank you, Carrie.
Next up on the Ask Carrie portion of the podcast, this is a question from Indiana, and she writes, should I really consider a prenuptial agreement if my fiance and I are both broke? All right, good question. So the answer is maybe, because the thing is this, is when two people get married, they have no idea what is going to happen during their marriage. Even though that they are both broke, doesn't mean that if they decide to dissolve the marriage, a politically correct way of saying get a divorce, that they won't have money at that point in time. And so I'm not sure what the law is in Indiana, but I can tell you that in New York and Illinois, where I primarily practice, the law is equitable distribution, not equal distribution, which means that the court looks at about 10 or 12 or 14 different factors to determine what is fair and just. And as you can probably imagine, people spend a lot of money fighting over what's fair and just in a divorce, right? And so if you have a prenuptial agreement, then it takes that out of the equation. You could just simply agree that we are going to split everything in the marital pie 50-50, or we're going to split it this way, or whatever it is that you agree upon. You can put that in writing. A lot of people also frown upon prenuptial agreements, but I look at them much like a life insurance policy. Nobody gets on an airplane thinking that it's going to crash, but you still go over the safety instructions. And I feel the same way about prenuptial agreements. It's basically just the insurance policy or the game plan of what's going to happen if things go haywire, so to speak. And if you have a question for the Ask Carrie portion of the podcast, please be sure to email me at carrie@rinkerlaw.com, spelled CARI, at rinkerlaw.com, spelled RINCKERLAW.com.